Hey guys, it's John Ween, attorney and legal instructor for Blue to Gold Law Enforcement Training, here with you today for another Roadside Chat. And the question today comes from an officer in Iowa. The question is, can officers enter a home with one person's consent while another person is denying access to the home? Yes or no? In a word, no. Officers cannot enter a home with one person's consent while the other person is refusing access to the home. So let's get into it here. A little background. Officers are called to a house for a possible domestic violence situation. Officers are greeted by two parties at the front door. One party gives consent, the other refuses to allow officers to come in. Important caveat here. While at the door, officers hear they see nothing to support a finding that exigency exists. And I'm going to take that a step further. Not only do officers not observe any circumstances indicating exigency, police dispatch received no information supporting exigency, nothing was reported by a neighbor to support exigency, there's no prior history at the residence or between the parties that could support a finding of exigency. We are operating purely in the realm of consent. The relevant case here is the 2006 Supreme Court case Georgia v. Randolph. In Georgia v. Randolph, estranged wife gave officers consent to search the marital residence for evidence of drug use. She gave that consent after Randolph unequivocally refused to give consent. So, officers went in, relying on wife's consent, and what do they find? They find the cocaine, they find the nose candy, the Colombian Bam Bam, right? And Randolph, he gets charged with it. This goes all the way up to the Supreme Court. And in a 5-4 decision, the majority concludes that consent of one resident does not override the refusal of another physically present resident who shares or appears to share common authority over the property, meaning they have or they appear to have the ability to give you permission. So let's look at the first part of that, okay? Georgia v. Randolph dealt with a physically present co-occupant. A prior case, U.S. v. Matlock, established the right of an occupant to give police consent to access mutual use and joint access property when the co-tenant was not physically present. In Matlock, the non-consenting resident was absent. He was absent because he was hooked up in the back of a squad car, but absent nonetheless. So the solution then seems obvious, right? If you find yourself in a Georgia v. Randolph situation, if you have two co-occupants, one who is going to consent and the other who isn't, well, you got to get that non-consenting resident out of there, right? You got to do a little Keanu Reeves in Speed action, and you got to take them out of the equation. Careful. In Georgia v. Randolph, the majority in dictum actually identified that consent by one occupant might not be sufficient if there is evidence that the police have removed the potentially objecting tenant from the entrance for the sake of avoiding a possible objection. In 2014, in Fernandez v. California, the Supreme Court held that Georgia v. Randolph was a narrow exception to Matlock. Again, Matlock, it established that the consent of a present co-tenant takes precedent over the objection of an absent co-tenant. One of the biggest takeaways from Fernandez was that, okay, I get consent from that present tenant, even if I know that absent co-tenant would object, or even previously had objected, as long as the objecting co-tenant's removal, either for arrest or for separation so that I can speak with the victim, as long as that removal from the area was objectively reasonable, it won't invalidate the consent. The court in Fernandez identified Fourth Amendment analysis does not incorporate an officer's subjective, right? The officer's individual intent. as long as the removal of the potential objector is objectively reasonable, it shouldn't impact the consent. As always, guys, remember, we change the facts, we change the answer. Randolph is two physically present co-tenants with equal authority over the property. One gives consent, one refuses. The refusal has it. Matlock, Fernandez, one present consent, another absent refuses. Even if the absent party is no longer there because police arrested him, as long as the removal was objectively reasonable in the situation, then the present occupant's consent is valid. I want to make this absolutely clear. This is purely dealing with consent. If you have another recognized exception to the warrant requirement, if you have exigency, if you have emergency aid, if you can articulate a reasonable belief that there is someone else involved, someone else who needs help, if there is an outstanding party, if there's a concern over destruction of evidence, then you're operating under a different set of parameters. I hope this helps. It's a good conversation. I love it. If you have any questions, any hypotheticals, if there's any specific training you would like to see, please email me at john@bluetogold.com. Until next time, my friends, thank you. Thank you for everything you do to keep us safe, to let us sleep peaceably in our beds at night. Stay safe out there.